Good afternoon, everyone. Tom Balzer here with the Ohio Trucking Association, and welcome to our Thursday show. Again, thank you to all of our sponsors who have supported us through the coronavirus coverage that we have been doing. Quick update of where we're at. 31,000, over 31,000 confirmed cases here in Ohio with 5,700 hospitalized. 1492 in ICU and 1843 as far as deaths go. Seeing the trend line from the United States as far as daily deaths continue to go down, peaks and valleys like we've talked about before, but really starting to see that taper off. Total deaths in the United States did go over 100,000. That was kind of a big marker that people were looking at, but they are projecting 131,000 by August 4th. As we all know, these projections go up and down moving forward. In Ohio, they're projecting 3,000, a little over 3,000 deaths by August 4th. And then the daily deaths, there again, peaks and valleys, but it's starting to level off and taper off as well. An interesting news slide was the one that talks about the volume of testing, and we're seeing that increase quite dramatically. The governor has done some initiatives, especially with long-term care centers, about getting the testing done. What we're seeing is the confirmed cases are really flat, even though the testing goes up. So that's actually a good thing. It's showing that there's actually a decrease in the percentage of, as more testing comes back negative of those confirmed cases. So, really kind of good news as far as that goes, is the testing increases. We're not seeing this monumental jump. In fact, we're seeing that being flat. So, so then today, for the remainder of our time, we have Greg Melick and Alex Karcher with us, who are part of a law firm member of ours, and have been extremely active in the association, and really happy to have them to talk about some of the legal impacts that we are seeing from the with regard to the orders the governor has and some of the other stuff that is there. Again, for those who have never been part of this, there is a Q&A panel that's part of that. So if you would type your questions in there, would be, and then we'll moderate those at the end. But I'm going to hand it off over to Alex and Greg to go ahead, and I just handed over hosting rights, so should be ready to go.
Good afternoon, everybody. I think we're unmuted. My name is Alex Karcher, and I am here with Greg Melick. We're attorneys with Luper, Neidenthal, and Logan. We have a host of practice areas here at our firm, transportation being one of them, and then, of course, litigation and employment law. So Tom has asked us to briefly provide an overview on the current landscape for coronavirus and the state of Ohio rules and regulations that are being enforced and enacted throughout the state. And of course, it's been rather difficult to keep up with them for businesses who, like you guys, who are all trying to simply keep freight moving. And it's been our job to try to stay up to date with them so that we can get you guys the best information we can. So since March 14th, when the original declaration of the state of emergency was issued by Governor DeWine, an additional 45 executive orders or director's orders from Amy Acton have been published. No doubt difficult to keep things straight and figure out what applies to us. For all of us in the legal field, we were deemed essential, just like most of you were, if not all of you were, in the original orders. So a lot of this hasn't changed from day one for us, except, ironically, we are now taking more precautions on the back end than perhaps we did on the front end while we were continuing operations in the initial stages of this. Today, we're going to briefly talk about the April 30th, 2020 Stay Safe Ohio order that was published by Amy Acton. That was sort of the initial business reopening plan, and it sets forth a lot of the expectations for employers that will continue until this crisis is resolved. We'll also touch on some CDC guidance and other OSHA and EEOC, Equal Employment Opportunity Commission guidance that has been issued to help employers navigate some of these murky areas of the law in light of these sort of unprecedented situations. Just as a general disclaimer, of course, we're only licensed here in Ohio, and we do have some attorneys that are licensed in surrounding states. But for those of you who have multiple terminals in locations out of state, a great resource that we've been pointing clients to and assisting them in sort of seeing what regulations exist at the state level is the csg.org website. I've linked this below. I can provide it to Tom. He's likely already sent something similar out to all of our members in the OTA, but essentially CSG is the Council of State Governments, I believe is the acronym. But in any event, the link here actually separates every single executive order that has been issued by state. And so it's a great resource to the extent you have to figure out what is going on where you have outlier terminals. So let's just jump right into face masks and what's required of businesses here in Ohio. This is the most visible interaction that we're having with the virus at this stage. It's also, I would say, probably one of the most debated, whether or not it's effective and who's going to wear them. So by and large, we must allow visitors as employers to wear face masks. It's not required for us to have any visitor into our facility wear them, but we cannot refuse their ability to do so. Pretty common sense. To the contrary, if you read the letter and spirit of the Ohio orders, employers are required to mandate that employees wear facial coverings, except for the limited circumstances that I have stated. This is obviously an area of contention where employers are having issues with when to enforce, when an employee refuses, and we also have to be very mindful that if an employee doesn't want to wear a face mask, we have to just be cognizant that there are other laws and regulations out there, the Americans with Disabilities Act, guiding EEOC mandates that require that we treat this very gingerly if an employee does in fact refuse to wear a face mask. The extent that we need to be prepared for some sort of enforcement action is in the event enforcement comes in, we need to be able to provide a written justification that explains why an employee is not required to wear a face mask. So Greg and I and Tom, we've all discussed the situation where an employee doesn't want to wear one, or the circumstances where perhaps they don't feel comfortable doing so. A lot of those could stem from concerns with medical conditions that make it hard for them to breathe. Perhaps if it's not feasible, so the situation, for instance, a manufacturing situation where you can't hear through a face mask and employees keep pulling them down. There are exceptions, for instance, that in the manufacturing context, it might not be practical for an employee to wear a facial covering because it makes it more difficult to communicate, for instance, in a safety sensitive nature. And so we just need to be cognizant of those exceptions, and the requirement to wear a face mask is not absolute. So social distancing, and if your video feed or we are appearing somewhere on your screen and it's blocking the text, you can click and drag it out of the way. But essentially under the orders, employers are required to implement social distancing practices. Here at our office, we've done that through tape on the floor around common areas. So our copy machines all have measured out 6-foot distances. we actually have an entire group of employees that work in a shared space. And in those situations, we've marked 6 feet out from their chairs so that if somebody's walking by them to get to the kitchen or something like that, they at least know how far they should stay away from that desk. And then of course, employees who work in that shared environment, even though we have cubicles with partitions, that sort of thing, common sense dictates that those employees should be wearing a face mask at all times. And that's where these guidelines have been a bit murky is, you know, the order says one thing, the guideline says something perhaps more strict or less strict than the order does. But by and large, what we're going to tell any of our clients at any point is that common sense prevails. As long as you as an employer are working in good faith to enact the spirit of these regulations within your employee context, we feel confident that we can explain and justify those situations. So in our situation here at L&L, we have cubicles in use. We have taken the position that despite what the order says and perhaps arguments that could be made to not require those employees to wear a face mask because they are in fact in their workspace, it's still inures to their benefit as a health and safety standpoint, but also to our benefit as an employer to make sure that we are protecting our employees as best as possible. Tape, signage on our bathroom doors. We have signs that indicate only one person should be in the bathroom at one time. Around our coffee machine, that sort of thing. We don't have enough space to have social distancing, so we've made that a one-person only station, and people disinfect things before they leave. We've done the same with our copy room.
Hand sanitizer and cleaning products.
Absolutely. So that's part of the order as well, is that hand sanitizer and cleaning products must be readily available both to employees and to visitors. I am not aware of whether or not those are still difficult to get your hands on or to get your hands on them at a reasonable price. Our office has actually made some, so we purchase spray bottles and they have signs on them with the proper usage and that sort of thing. The guiding precedent is that it should be an alcohol-based disinfectant with at least 60% alcohol. But by order, those need to be made available to staff and visitors. Of course, if you can work from home, do so as feasible. We understand in the transportation industry that's not always practical. And so we just need to use good judgment. And to the extent we can do so, do it. Otherwise, just be as safe as possible in our environments. So sick policies, if you don't have one, now is the time to get one in place. And we would recommend that any employment policy updates that you do, you run by your employment attorney, whoever that may be. If you have a current sick policy, now is a good time to update it if necessary. But in essence, the guidelines that have been produced by the CDC and by the state of Ohio are pretty clear on what we need to do if in fact somebody gets sick. Whether or not that's with COVID-19, suspected COVID-19, or perhaps confirmed COVID-19, which we'll touch on in a little bit. But of course, send them home if you have an employee that exhibits any illness. And in fact, you need to take affirmative actions as an employer to limit their access to the building to the extent they might not willingly leave work. So we are all guilty of it. We want to be worker bees. We want to be in our office being productive for our clients, whether that's a shipper or in our case, our transportation clients. But to the extent we have somebody that's not going to obey and they are exhibiting signs and symptoms, we do need to take steps to actually deactivate their access to the building. Of course, I've listed the guidelines below for if an employee is exhibiting symptoms. Those are guidelines. They aren't mandates, but a reasonably prudent employer would adhere to the guidelines, which is pretty much what every executive order has specified. So we touched on this a little bit, but if work from home isn't practical, it is certainly practical in most applications to stagger hours. So while a dispatcher might need to be present because your software doesn't have remote capabilities or whatever that reason may be, it does make sense that perhaps the accounting team doesn't need to be there at the same time the dispatcher is there, or vice versa. Perhaps somebody can come in from 9 to noon, leave a bit early, work from home the rest of the day if that's possible, and the accounts team can come in later during business hours. Of course, off business hours are also acceptable, but to the extent you can stagger hours for any of your staff to limit the amount of people coming and going from the building or remaining in the building at one time, that makes sense to do so. That's what the state of Ohio is going to expect employers to do, where practical. So protecting drivers, this is of course something that we all need to be mindful of because drivers are our best resource in the transportation industry. So the CDC has actually published what's been titled What Long-Haul Truck Drivers Need to Know About COVID-19. We believe this has gone out in a prior OTA email. If not, it's searchable on Google. You can find it right away. But I would suggest that every employer do a really deep review of that 4-page document. It's been written so that anybody can understand it, but it's going to talk a lot about how we need to protect drivers, much of which you've probably already been doing either because you got out in front of it or because your shippers have required it. Some notable things, provide all your drivers with their PPE so that they don't have to be sharing it or receiving it from shippers. Hand sanitizer should be in the vehicle and provided by the employer. To the extent you have team driving, of course, limit that as possible. The guidance does specify to put up some partition in the cab. I don't think that's necessary so long as you're taking precautions, but more than necessary, I don't know if it's practical. You can't separate the cab of a vehicle. So obviously take some of these things with a grain of salt. We don't need to do expensive retrofits of our cabs, but to the extent we can separate off the sleeper berth from the cab, do so. Usually a curtain's already in place, so that's totally sufficient. Just be mindful that there is continually changing guidance on whether or not the virus can live on surfaces, and cloth surfaces, it may do so longer. So we should be educating our employees as part of the regulations as to good hygiene and disinfectant practices. So we do need to begin, if we haven't already, actually producing, I would call it white paper for our business that sets forth good practices for hygiene, hand washing, disinfectant, etc. That's all very easy things that we can do simply to leave a paper trail to protect you later on from either the government or perhaps a complaint that from an employer or a visitor, or an employee or a visitor or something like that, that we aren't necessarily doing what we need to do. So we want to make sure that we're really setting forth the policies for all of our visitors and our employees. Make a plan, especially if you're drivers. What happens if they get sick on the road? Where do they go for medical treatment? Alternative plans for freight delivery. Do not, under any circumstance, encourage a driver to deliver a load if they are currently in transit and they have told you that they are sick. That would almost certainly deviate from best practices and might open you up to liability from a shipper should that disease spread, et cetera. So we just want to be very mindful of that to the extent we need to drop a load and have somebody else finalize it. Let's see, consider having drivers keep alternative records. This isn't in the guidance. I just think it's good practice. We, of course, have shipping documents and other bills of lading that get signed off, but usually that's not actually a contact tracing tool. That's not what it's intended for. Those signatures are often illegible. So I think it's a good idea to have a clipboard or something that the driver can keep track of who they interact with as shippers, just in case they do get sick, so that we can go back as good clients of our shippers and inform them that we did have this incident and that this is the person that they came in contact to on the loading dock. Obviously, you guys are all aware that lots of shippers are requiring drivers not exit the vehicle while unloading and loading. We totally encourage all of that to continue and to limit driver interaction with outside parties as best as possible. That also goes for when they return to your terminal or your place of business. We should be limiting the amount of people that enter into the place of business at all times. That's all common sense and things that you all have heard quite a bit over the last few weeks, but that is what would be expected of an employer. So we have a number of things that we need to proceed with caution about. We've touched a little bit on EEOC supplemental guidance. We have a slide coming up to talk with that. We also have to be mindful of the Americans with Disabilities Act and asking questions of employees about their health conditions, perhaps when they're going to return to work or if they feel well enough to return to work soon. Those are all questions that we should be very cautious about asking. And of course, we need to be mindful of unintended audiences as we continue to increase our virtual presence. So I'll touch on the last first. Obviously, and this came up in a meeting with another OTA member last week, and I thought it raised a really important consideration, which is all of these safety meetings, often that you guys are performing on a quarterly basis, those have all turned to quarterly virtual meetings. And a lot of times those meetings used to go over incidents that occurred in prior quarters and what we did wrong, how to correct it, and best steps going forward. Those meetings are now being conducted more virtually through avenues such as this, and there is a heightened ability for somebody to push the record button. Our meeting today is being recorded. Sometimes you know that that's being recorded, other times you don't. But we have to be mindful that if we get involved in future litigation, those recordings are almost certainly going to be subject to production and discovery in the event of an accident or anything else that occurs. And so we just want to be mindful that, we need to tell employees what the expectation is. Whether or not they can record or shouldn't record, we should be very open about that. If we are recording, we should tell them up front that we are recording. We also need to be careful about recording if we have people tuning in from other states, because state laws vary on who can record and what consents are required. So we need to be open about that. We need to be cautious and provide an open warning that anything said could be seen by multiple audiences, and that goes for anything that we do, emails, texts, all of that at all times. So just remember that as we continue to go virtual, those sorts of things could be exploited later on, and we don't necessarily want to take a private conversation that was meant for internal purposes and turn it into something that could be used against us. So there's a lot of text on this screen, but I think it's really important for everybody to understand that all of this is changing. And if there's one takeaway today from this presentation, it's that this is unprecedented and we don't have a lot of concrete guidance here in Ohio or nationally on how these are going to be enforced and the standards to which an employer is going to be held responsible. We take the position that so long as an employer is operating in good faith and exercising reasonable diligence to make sure that the employees are informed, that the tools are available to protect themselves, and that we as an employer have taken proactive measures to combat COVID-19 in our workplace, that should be enough to protect you. It's going to be factually specific for each case, but there is a wealth of guidelines out there that anybody can search for. The EEOC and the ADA themselves have published some guidelines. So these are some of the ones to highlight. Employers may screen employees who enter the workplace, but they may not exclude an employee from the workplace simply because they're in a high risk group. So we can't say Joe Smith is 65 years old. He's a bit overweight. We know he has a heart condition because we've been monitoring that as part of the, part of the federal requirements after an open heart surgery or whatever it may be. And so we aren't going to let him into the workplace. We absolutely cannot take that position. That would be in violation of the Americans with Disabilities Act and the EEOC. Our office has a thermometer up front. That would be a reasonable step that an employer should take if they can get access to a thermometer. And they should probably be taking people's temperatures as they enter the building, just as a preventative measure to make sure that nobody ill or actively exhibiting symptoms is entering. You can keep a log of those temperatures. So not required, not even really suggested to track it. In fact, I don't really see how there's much value for an employer to track that information, nor do I think it's good to keep it. But the EEOC has addressed this. And if you do decide to take a temperature and log it, just be mindful that it should not be stored in any publicly accessible place. So you should keep it on like a password protected file or something like that. Do not disclose employee medical conditions to other employees. So if somebody is ill and tests positive for COVID-19, as an employer, do not send an email to the rest of the office saying John Smith has tested positive for COVID-19. That is something we want to be very careful of. You may disclose this name of the employee who tests positive to a public health agency. We don't suggest doing that. In fact, if you go to any testing site or anything like that, they're probably going to make you sign a waiver. And regardless of if you sign it or not, that testing agency is going to be required under current emergency declarations to submit your positive test or an employee's positive test to a state agency. We don't recommend employers get involved in that process. It just gets you in the middle when you don't need to be. To the extent somebody requests a reasonable accommodation because they have a disability and are fearful that they might need added protections to protect them against COVID-19, those protections are going to be what you're seeing pop up everywhere for cashiers, or for instance, somebody in the cubicle. It might be a partition. It might be added hand sanitizer, a private office if one is available. Things such as that are going to be and have explicitly in the guidance been found to be reasonable accommodations that an employer may be expected to provide. Under the ADA, we of course want to be mindful of the information that we're requesting and the specifics that we're requesting of an employee. If this issue arises, it's always best to consult with your employment attorney just to make sure that you aren't overstepping any of your bounds as an employer. Sort of touched on this a little bit. Medical information under the ADA cannot go into a personnel file. It cannot be disclosed to others. This includes driver DQ files. Of course, 49 CFR regulations all apply for drug testing, all of that, of course, all that stays in your DQ file. But to the extent we accumulate or assemble any medical information on an employee, whether that's a temperature check or we find out they have had COVID-19 and we're trying to gather negative tests to demonstrate that we have complied with those guidelines, just make sure that all of that stays in a separate file that should be under best practices protected by password or otherwise if it's in paper form in a locked cabinet, that sort of thing. And then this is sort of looking to the future. Have a plan. Statistically, it is possible, if not perhaps probable, that at some point a business is going to have an employee that is impacted by COVID-19, in part specifically test positive themselves. And so as an employer, it is going to be expected that we have a plan in place, that we're ready. We recommend that take the form of a team. You should assemble and assign a team now, composed principally of leadership, but perhaps even others. So if you have a dispatcher that you think could provide some insight as to what the day-to-day operations look like. If you're a larger outfit, if you're a smaller outfit, the team just may be one person. But we need to designate a person that is both the contact for an employee, for a driver, and then importantly also the person who is going to be in charge of answering any media questions should that occur. Those point people should all be designated before anything happens. And so that should be something that's ongoing now. We also need to be prepared to temporarily shift operations out of the workplace. So if somebody tests positive today at Luper, Neidenthal, and Logan, we would temporarily shut down the office so that we can do a deep clean, probably through a industrial cleanup crew of some sort to ensure that all surfaces have been cleaned. And we would then begin the process of coming back. But at least for that temporary period, we would have a plan in place to shift all work outside while we do that cleanup response. Make those investments now to the extent you don't have the software or capability to do so. To the extent you don't want to sign up, if you need to pay for a subscription or software or something like that, at least have the plans in place so that all you have to do is click submit to whatever software company you're using so that you can get live quickly. Crisis response, this is a great sort of image that I found online. It explains this to a T. Just be ready. That's the takeaway there. And with that, Tom, we'll open it up to questions and of course provide answers as best we can. We hope that's been a bit of an overview, but again, the takeaway is employers need to act reasonably, need to actually review some of the information that has been published by the CDC, the state of Ohio, so that they can understand it. And of course, should some enforcement be enacted or a complaint be filed, we need to be able to describe in writing why we have taken the steps that we have. And that of course includes from an evidentiary standpoint, attaching as exhibits all of those policies that we have put in place, all of the signs that we have hung up, directing people to wash their hands and how to properly wash their hands and how to sanitize, etc.
Alrighty, thank you all very much for that information. Greg and Alex, and Greg, I apologize for the mispronunciation of your last name. I knew I was going to do that, and I practiced 3 times beforehand, and I knew I was going to nail that one the wrong way. The Q&A panel is open, so please provide that for me. Go ahead and use that. First question is, are you going to be able to provide a copy of your PowerPoint? And Alex, if you are, just send that to me and we'll get that posted onto the website behind the member side of it, if that's something that you guys are able to do. So we will, if we can do that, we will definitely do that. I guess one question that I had is, let's say that you have an employee who believes that you are not abiding by the protocols, and they're doing their own, everyone loves to sit around and watch Wine with the Wine at 2 o'clock, and everyone becomes a mini attorney. How far does an employer have to go in order to accommodate employees who feel that their employee, to accommodate those employees' concerns? I mean, at what point is that limit?
I think best practices is if you follow the governor's and Amy Acton's guidelines, you should be good. As Alex said, you have to be mindful of people that might have disabilities. And when I say disabilities, everybody is going to have some level of anxiety coming back to the workplace. I'm talking about people that have pre-existing anxiety disorders that might need to be sat down and talked to, and quite frankly, accommodated in one of the manners that Alex described. But our firm's opinion is, if you follow the EEOC's guidelines, if you follow the governor's orders and Amy Acton's orders, you're kind of in a safe harbor there, and you can tell your employee that you're doing everything that the state required you to do, and that's all that's required.
So in that same vein, is this how do you see this play out? Is there cause for civil action against an employer if they do not feel that they are following these orders? Does this order have that same effect, that they're able to do that?
I think that's on the horizon, Tom, and as everybody that's on this may have seen, there is legislation being drafted in the United States Congress to give employers immunity from lawsuits. I haven't seen an article that tells me what Mitch McConnell's actually talking about when they're drafting that, because as we all know, the workers' compensation laws take care of us if one of our employees gets sick. So I'm not quite sure what type of immunity he is talking about. My guess would be he's talking about that immunity from civil suits for not, I guess, subjectively complying with any individual employee's desires in the workplace. So we'll need to keep an eye on that.
And the state of Ohio is also looking at that as well, providing some immunity protections for employers that we have been advocating for quite a few months. That was pretty early. So the next question, and it's kind of two questions, one of which was I was going to ask, and then we came across the board, was what if an employee has an anxiety wearing a face covering but can't get a doctor's release not to wear the face covering? So the question is, if an employee has some sort of condition like claustrophobia or whatever, that side of thing, that they want to use not to wear a face covering, do they need specific written doctor's orders in order to do that? Or can they just say, I can't wear this mask because I feel claustrophobic, or, I've got anxiety, or whatever that case may be? What is that standard?
Well, there's not a standard, but let me give you some advice or an opinion on that. Right now, I think it would be very difficult for that employee to actually get a doctor's note. Our doctors are a little bit busy doing other things right now. And you've also got to be careful about, under the ADA, you're not allowed to ask about certain medical conditions. That's a tight one. If one of my employees came to me and said they had a health reason, any health reason, whether it's physical or mental, I'm probably going to err on the side of accommodating it, to be honest with you.
And in that vein, Tom, we would simply, as an employer, have to be able or ready to explain why we did not require that employee to wear a face mask. But we would take the position that a certain verbal sort of explanation by the employee of why they don't feel comfortable wearing a face mask for any mental or physical ailment, I won't even go as far as say disability, that would be enough.
And Tom, I would take that position only now in the current COVID-19 circumstances. If this were a different time and somebody said they couldn't use the copier because they have copier anxiety, I would probably require that they get a doctor's note for that, but we're in a different time.
Next question is, do you have any tips on how to work with employees who are not concerned about COVID-19 and not complying with company policies such as masks unless a supervisor is around? What are the potential implications for an employer if they do have these policies in place, but employees are unwilling to follow them?
Technically, I'll give you the technical answer, Tom. If they're not complying with your policies, you should send them home, is what you should do. That's the easy answer. I mean, the more difficult answer is, and all of the EEOC and the ADA suggest that you do that you as a conscientious employer sit down with them and try to figure out if this is a real problem or this is some type of conscientious objection based on some other reason. As you and I and Alex spoke about on the phone yesterday, masking is the biggest, hottest issue out there right now. And if you may recall when the governor first came out and was going to require everybody to have masks, that lasted less than, I believe, 36 hours. And if anybody remembers that, because that's one of our state reps from Urbana said that that violated his religious rights as a Christian, because he can't wear a veil on his face because we're all made in the image of God. And within 36 hours, Governor DeWine backed off from that. I think you're going to get those types of pushbacks, deal with them on a case-by-case basis. I mean, I think you're going to have to subjectively, measure their seriousness and see if they're real or somebody's just being, a pain in your ass. But masking is probably the biggest issue that you're going to encounter. It's been the biggest one I've dealt with so far.
And from a practical standpoint, assuming that this is an at-will employee that is disregarding the business's policy, and of course that's a written policy that's been put in place and circulated, if it is an at-will relationship, Ohio law very clearly states that an employer may change the terms of condition of employment every single day. If they want to change the policy that employee must abide by every single day, they can do so, and failure to comply with that policy could be a terminable offense. Obviously, employees are our best assets, drivers are our best assets. We don't want to go around terminating employees, but if it does become an issue and it's a very clear violation of the policy and your handbook permits it, then that might be a situation where you could act accordingly.
You advise that it is not recommended to advise other employees if someone within the company contracts the virus. How then do we find out who else may have been in contact with that employee?
So we should not be specifically identifying the person who has been tested positive for COVID-19. That would be a violation of their privacy rights and medical information. How we would approach this is we would draft a generic letter. We would call or somehow meet with the individual who's tested positive. We would find out through them who they have been in close contact with, and then we would provide a generic letter to those employees or other employees saying, we believe you have been exposed to coronavirus, perhaps even including the date range that exposure may have occurred, encouraging them to monitor for signs and symptoms. You might even go as far as to require that individual to self-quarantine if it was an extremely close contact, but we would not directly identify the individual who has tested positive. Of course, that doesn't stop the rumor mill from churning, and of course that individual from sharing their diagnosis, but we don't want to be the arbiter of who decides or who finds out what an employee's ailment is versus not. That should not be the employer's role.
All right, so that seems to have exhausted our Q&A. Gentlemen, thank you so much for participating with us today and sharing this information. I know that this has been a extremely hot topic. I've spent more time on the phone the last couple of weeks trying to figure this all out, and as you guys had identified, primarily the face coverings piece going forward, and I know this will be a work in progress as we move forward. So again, just a reminder to the audience, this webinar series is going to continue and will be only on Thursdays, so will not be one on Monday. But we'll get back to the regular schedule of every Thursday going forward as we continue to do this. And this is going to be a permanent fixture or member service that we have available to our members. So again, gentlemen, thank you so much. And we will be back with you next Thursday.
Thanks, Tom.
You're welcome.
Appreciate
Thank
it.
you, Tom.